5, the Honorable Michael B. Carpenter presiding.
Thank you, everyone. Please be seated. Nice job, Deb. All right, we're back on the record. The People's State of Michigan versus Jawan Curry, file 20-1125 SM. Counsel, identify yourselves for the record.
Thank you, Patrick Schminsky for the people.
Good afternoon, Your Honor. May it please this honorable court, Brian G. on behalf of the defendant.
All right, we're about ready to bring the jury back in. We've had an opportunity to reprint the jury instructions. We had an opportunity to review them, Mr. Swinski, and are there any objections to them?
I've reviewed them and I have no objections.
Mr. Jean, same questions.
I have reviewed them, no objections.
All right. Any issues we need to address before we bring the jury in, Mr. Swinski?
No, Your Honor. I do know the packet includes all the instructions, but I'm assuming we're just reading the after proofs. Okay.
Yeah, I'm going to tell them, the jury, that's a good point. So I will instruct the jury to go to page 11 of 18 because I've already read pages 1 through 10.
Thank you.
All right, anything else, Mr. Jean?
No, Your Honor.
All right, please bring the jury in. I'll rise for the jury. Record will reflect that the jury is back in. Ladies and gentlemen, please be seated. Ladies and gentlemen, I have good news and better news. How about that? There's jury instruction packets, so each of you will take those. There's 18 pages of instructions that need to be read. The better news is we start on page 11. So if you could pass the jury instructions down, turn to page 11. Once you're on page 11, you don't have to follow along, but at least you know where I'm going and where I'm getting the instructions from. Once you get to page 11, please look up so I know that everyone is there before I get started. All right. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all of the evidence and then decide what piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some of the instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept the things that lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your question to the witnesses, and my question to the witnesses are also not evidence. You should consider only these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August 19, 2020 within Midland County. When you go to the jury room, you will be provided a written copy of the final jury instructions. These are the final jury instructions. You should first pick a foreperson. Foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. I am not going to require a sealed envelope, just a written statement, and you'll knock on the door and give it to Ms. Jason. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all the reference documents or exhibits that have been omitted, just ask for them. I think we're going to allow all of the exhibits except the video footage. If you wish to have that, that must be played here in the courtroom with everyone present. Am I correct in that, Mr. Jean, regarding the other exhibits? No objection to them having those?
Correct, Your Honor.
You agree, Mr. Schwinski?
Yes, I do.
Okay. When you go to the jury room, you'll be getting a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from the outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You may consider whether the defendant had a reason to commit the crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the crime, the alleged crime. He only has to show that the defendant actually committed the crime and meant to do so. You have heard evidence that was introduced to show that the defendant committed improper acts for which he is not on trial. You must not consider this evidence for any other purpose. For example, you must not decide that it shows that the defendant is a bad person or that he is likely to commit crimes. You must not convict the defendant because you think he is guilty of other bad conduct. All the evidence must convince you beyond a reasonable doubt that the defendant committed the alleged crime, or you must find him not guilty. The defendant's intent may be proved by what he said, what he did, how he did it, or any other facts and circumstances in evidence. You should not decide this case based upon which side presented more witnesses. Instead, you should think about what each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There is nothing wrong with this. A lawyer may talk to witnesses to find out what the witness knows and about the case and what the witness testimony will be. You've heard testimony from a witness who is a police officer. Witnesses who are police officers, that testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. The defendant is charged with the crime of domestic assault. To prove this charge, the prosecutor must prove the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Katoria Crawford. A battery is the forceful violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Katoria Crawford's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Katoria Crawford reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit the battery, or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time, Katoria Crawford was a resident or former resident of the same household as the defendant, or was a person with whom the defendant had or previously had a dating relationship. A dating relationship means frequent intimate association, primarily characterized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. Third, that the assault caused a serious or aggravated injury. A serious or aggravated injury is a physical injury that requires immediate medical attention or that causes disfigurement, impairment of health, or impairment of part of the body. The last page is just the possible verdicts. You may return only one verdict on this charge. Mark only one box on this sheet, and that would be the foreperson. All of you would agree on that. And that would be either not guilty or guilty of aggravated domestic violence. Mr. Swinski, after reading through the final instructions, is there any corrections, changes, additions that need to be made?
No, Your Honor. Thank you.
Mr. Jean, same question.
None.
Okay. At this point in time, the jury, I need to swear in the bailiff, and then we will have the jury decide to deliberate. So, Jason, if you would, please. You do solemnly swear or affirm that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communications to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict, until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they've agreed upon, so help you God. Okay. At this time, Mr. Jason, if you would take those. Please rise for the jury. It is now time to talk about the case. Not yet, until you get to the verdict. The record will reflect that the jury is now in jury room, but the door is still open, so I'm going to wait. And now the door is closed. Go ahead and you may be seated. Is there anything else we need to place on the record before we adjourn, waiting either a question or a jury verdict, Mr. Schwinski?
No, I think Ms. Jason has a question.
I'm sorry.
Any objections?
Sorry,
on
Ms.
that?
Jason, we cannot hear that on the record.
They were asking for sticky notes. Any objection to the sticky notes, Mr. Jean?
None, Your Honor.
Any sticky note problems, Mr. Schwinski?
No, Your Honor.
All right,
Thank you.
Mr. Jean, anything you'd like to place on the record before we adjourn until we get a question or a verdict?
No, Your Honor. Thank you.
All right, thank you. We'll be off the record. Thank you.